The school parking lot was already half full when I pulled in at 8:17 a.m., balancing a travel mug in one hand and my son's blue backpack in the other, thinking only about whether I'd remembered to sign his math quiz. I had no idea that by 8:24 I would be standing in the main office of Ridgeview Elementary School being told that, according to their records, I was no longer my own child's legal guardian. My name is Vanessa Halloran. I am 38 years old, a licensed dental hygienist, and the mother of a 9-year-old boy named Caleb. Until that morning, every form at Ridgeview listed me as mother/primary contact. I had filled them out myself at the kitchen table in black ink. I had uploaded my driver's license, Caleb's birth certificate, and the certified copy of my divorce decree from the Circuit Court of DuPage County. I am not a person who ignores paperwork. I keep a labeled file box in my hall closet. Caleb hopped out of the car before I'd even turned off the engine. "Mom, you forgot my permission slip," he said, leaning back in through the open door. I handed him the folder and told him I'd walk him in because I needed to drop off the field trip payment. It was supposed to be routine sign-in at the front desk, smile at the secretary, remind Caleb to hang up his coat. Inside, the front office smelled faintly of dry erase markers and lemon disinfectant. The walls were covered in laminated posters about kindness and attendance. Behind the counter sat Mrs. Donnelly, who had worked there since Caleb started kindergarten. She looked up, smiled automatically, and then something in her expression shifted. "Good morning, Vanessa," she said, but her tone was tighter than usual. She glanced at her computer screen again. "Can you wait just a moment?" Caleb tugged on my sleeve. "Mom, I'm going to be late." "You're fine," I said and kissed the top of his head. "Go hang up your coat. I'll be right there." He disappeared down the hallway toward room 204. I stepped closer to the counter and slid the sealed envelope with the field trip money toward Mrs. Donnelly. She didn't take it. Instead, she lowered her voice. "I need you to come into the principal's office for a minute." My first thought was that Caleb had gotten into a fight. My second thought was that maybe there was an issue with the field trip waiver. It did not cross my mind that this had anything to do with custody. I followed her down the short corridor to the office of Principal Karen Whitmore. The plaque on the door read K. Whitmore, Master of Education. I had met her twice, once at an open house, once at a PTA meeting. She was efficient, measured, careful with her words. She stood when I entered. "Miss Halloran," she said, "please have a seat." There was a man I didn't recognize sitting in the chair opposite her desk. He wore a gray suit and had a legal pad open on his knee. He did not introduce himself. I remained standing. "Is Caleb okay?" "He's in class," Principal Whitmore said. "This isn't about his behavior." I sat down slowly. My heart had begun to beat harder, but I kept my face neutral. "There has been an update to Caleb's custody file," she continued. "We received documentation late yesterday afternoon indicating that you are no longer listed as his legal guardian." For a moment, I thought she must have confused me with someone else. "That's not possible," I said evenly. "I have sole physical custody. His father has supervised visitation every other weekend. That hasn't changed." The man in the gray suit cleared his throat. "Ma'am, are you aware of a recent court filing in DuPage County regarding temporary guardianship?" "No," I said, "because there hasn't been one." Principal Whitmore turned her monitor slightly so I could see the screen. On it was a scanned document with a county seal at the top. The header read, "Petition for temporary allocation of parental responsibilities." Beneath it was my ex-husband's name, Daniel Mercer. The document stated that Daniel Mercer had petitioned the court for emergency temporary guardianship of Caleb Halloran, alleging that I was medically unstable, failing to provide appropriate supervision, and withholding access in violation of prior court orders. I felt the room tilt slightly but kept my hands flat on my thighs. "That's fraudulent," I said. "There was no hearing. I haven't been served." The man in the suit spoke for the first time directly to me. "I'm Paul Anders, counsel for Mr. Mercer. The petition was filed yesterday morning. An emergency order was signed pending a full hearing. The school was notified because the order includes immediate educational decision-making authority." He slid a copy of the document across the desk toward me. I did not touch it. "I was at work all day yesterday," I said. "No one served me any paperwork." No one contacted my attorney. This is not valid. Principal Whitmore folded her hands. Ms. Halloran, I'm not here to debate the court order. Our responsibility is to follow what's been filed with us. As of this morning, Mr. Mercer is listed as Caleb's legal guardian of record. That's incorrect, I repeated. Even if a petition was filed, I have to be notified. There has to be a hearing. Mr. Anders' voice remained controlled. The court granted temporary emergency authority based on the affidavit submitted. Based on what affidavit? I asked. He looked down at his legal pad briefly, then back up. An affidavit stating that you were recently hospitalized for mental health concerns, and that your condition poses a risk to the minor child. I stared at him. I have not been hospitalized, I said. Ever. Principal Whitmore shifted slightly in her chair. Vanessa, we're not making a judgment about your health. We're simply complying with documentation provided. Who provided it? I asked. Mr. Mercer's attorney's office, she replied. I looked at Mr. Anders. You represent Daniel? Yes. When was this signed? I asked. Yesterday at 3:42 p.m. I pulled my phone from my purse and opened my calendar. Yesterday at 3:42 p.m., I had been finishing a dental cleaning for a patient named Marjorie Klein. I remembered because she had rescheduled twice and complained about the fluoride treatment. I have time-stamped patient records, I said calmly. I was at work. I was not in a hospital. I was not incapacitated. And no sheriff has served me with anything. Mr. Anders did not argue that point. Service is being arranged, he said. However, emergency orders can be implemented immediately in matters involving alleged risk to a child. Principal Whitmore leaned forward. Until this is clarified, we cannot release Caleb to you without Mr. Mercer's authorization. The words landed slowly. I just dropped him off, I said. Yes, she said gently. And he can remain in school today. But at dismissal he will be released only to the guardian listed in the current order. I understood exactly what that meant. You're telling me that at 3:05 p.m., if I come to pick up my son, you will not give him to me. Principal Whitmore hesitated, then nodded. Unless the order is reversed or clarified by the court. My voice did not rise. Have you contacted Child Protective Services? No. Has there been any investigation? No. Has Caleb reported any concerns to staff? No. Then on what basis? I asked, looking directly at her. Are you treating me as if I'm a danger to my own child? She held my gaze but did not answer the question directly. We have to follow what's in front of us. I turned back to Mr. Anders. Where is Daniel right now? He will be arriving at dismissal, he said. Of course he would. Daniel Mercer had not attended a single parent-teacher conference in 3 years. He had missed 2 supervised visits in November. He paid child support irregularly and complained about the supervision fees. But apparently he had found time to file an emergency petition, accusing me of psychiatric instability. I want a copy of everything you've submitted, I said. Mr. Anders slid a stapled packet toward me. This is the petition and the signed temporary order. I finally picked it up. The affidavit was 3 pages long. It claimed that I had recently exhibited erratic behavior, that I had threatened self-harm, and that Caleb had expressed fear of returning home. It cited an incident 2 weeks prior in which I allegedly left Caleb unsupervised for several hours. None of it was true. The document included a typed statement attributed to a concerned third party. The name listed was Laura Simmons. Laura Simmons is my neighbor. She has borrowed sugar from me twice and once asked me to sign for a package when she was out of town. I felt something colder than panic settle in my chest. I have never threatened self-harm, I said quietly. I have never left Caleb unsupervised for hours. And Laura Simmons has never raised any concern to me about my parenting. Mr. Anders' tone did not change. These matters will be addressed at the hearing. When is the hearing? I asked. Monday at 9 a.m. in family court. Today was Wednesday. You expect me to go 5 days without custody of my son based on this? I asked. It's temporary, he said. Temporary. I looked at Principal Whitmore. Has Daniel been given access to Caleb's records? She hesitated. Under the temporary order, he has educational decision-making authority. Answer the question, I said evenly. Yes, she said. I nodded once. Then I need you to document in Caleb's file that I dispute this order, I said. That I have not been served, and that I have requested verification directly from the court. She reached for a pen. I can note your statement. Please also note, I continued, that I am requesting a copy of the transmission record showing when and how this document was delivered to the school. Mr. Anders shifted slightly. There's no need to escalate. I am not escalating, I said. I am documenting. There was a pause. Principal Whitmore began writing. I stood up. I will be contacting my attorney immediately, I said. And I will be calling the clerk of court to confirm whether this order is legitimate. Mr. Anders closed his legal pad. You're within your rights to do so. I walked out of the office without another word. In the hallway, I could hear Caleb's class reciting multiplication tables. His voice was among them, steady, confident, unaware. I did not go back into the classroom to say goodbye again. I did not want him to see my face. Instead, I walked straight out to the parking lot, got into my car, locked the doors, and dialed my attorney, Rachel Kim. Rachel answered on the second ring. Vanessa. I'm at Caleb's school, I said. And they just told me I'm not his legal guardian anymore. Rachel was silent for half a second, the kind of silence that means she's shifting from listening as a friend to thinking as counsel. Start from the beginning, she said. I put the phone on speaker and set it on the passenger seat. I described the meeting in the principal's office, the emergency petition, the allegations about hospitalization, the affidavit from Laura Simmons, and the temporary order signed at 3:42 p.m. the previous day. They said it was an emergency allocation of parental responsibilities. I finished. They're refusing to release Caleb to me at dismissal. Rachel didn't react emotionally. Did they show you a file stamp? Yes. County seal? Yes. Judge's signature? Yes. Handwritten or electronic? Electronic. Okay. I could hear her typing. Give me 10 minutes. Don't leave the parking lot. I have to get to work, I said automatically. You're not going to work, she replied. You're going to the courthouse. I ended the call and sat there with both hands on the steering wheel, forcing myself to breathe evenly. I replayed every sentence in the affidavit in my head. Medically unstable. Threatened self-harm. Child expressed fear. It wasn't just a custody maneuver. It was character assassination. 9 minutes later, Rachel called back. There is a filing, she said immediately. It was entered yesterday afternoon in courtroom 3B. So it's real. It's real in the sense that it exists, she clarified. That doesn't mean it's legitimate. What does that mean? It means Daniel's attorney filed an emergency petition, and a duty judge signed a temporary order based solely on what was presented. That's not uncommon in ex parte requests. Ex parte, I repeated. One-sided. You weren't there. Because no one told me. Correct. I leaned back against the seat. How do they get away with that? They don't, she said. Not if we respond properly. I watched a group of second graders crossing the parking lot holding hands in pairs. They're saying I was hospitalized, I said. Rachel, I wasn't. I know, she said. We'll need proof. Employment records, timesheets, patient logs. I can get those today. Good. We're filing an emergency motion to vacate the temporary order. I'm also requesting immediate clarification regarding service. If you haven't been served, that's a procedural issue. Caleb gets out at 3:05, I said. Daniel's planning to pick him up. Rachel paused. We may not be able to stop today's dismissal. The sentence hit harder than anything else so far. So he just takes him? I asked. For now, she said carefully. Unless we get in front of the judge before then. What are the odds of that? Low. But I'm going to try. I started the engine. Where do you want me? Family courthouse. 3rd floor clerk's office. Bring ID. Bring your divorce decree. Bring any documentation showing no hospitalization. I'll be there in 20. I ended the call and drove. The courthouse in DuPage County is a beige concrete building that looks like every other suburban government structure built in the late 1980s. Functional. Impersonal. I had been there once before for my divorce hearing. I never imagined I would be back, because my ex-husband had accused me of psychiatric instability. Rachel was already in the lobby when I arrived. She had a legal pad tucked under her arm, and her hair pulled into a low bun. "Let's move," she said. We took the elevator to the third floor. The clerk's office was fluorescent lit, and busy with people waiting in plastic chairs. Rachel went directly to the counter. "Case number 22F, 1847, she said. "We need the full docket and a copy of yesterday's emergency petition and order." The clerk typed, printed, and slid a packet through the slot. Rachel flipped through it quickly. They attached an affidavit from Daniel and a supporting statement from Laura Simmons, she said. And a note from a licensed clinical social worker. "What?" I said. Rachel turned a page. "There's a letter here. It says you were evaluated for acute depressive symptoms and advised to seek inpatient treatment." "That's not possible," I said. "I haven't seen a social worker." Rachel scanned the letterhead. "This is from a practice in Naperville." "I've never been there." She looked at me directly. "Vanessa, is there any chance Daniel had access to your medical records?" "No." "Any shared insurance portal?" "No." She nodded once. "Then this letter is either fabricated or misattributed." "Fabricated how?" I asked. "Forged. Or taken from someone else's file." The idea felt surreal. Rachel turned back to the clerk. "We need certified copies of everything filed yesterday." While the clerk prepared the copies, Rachel stepped aside with me. "Listen carefully," she said. "An emergency order like this is designed to be temporary. Judges sign them quickly because they err on the side of caution when a child's safety is alleged." "I'm not a danger," I said. "I know. But the judge doesn't know that yet." She lowered her voice. "Daniel's strategy is clear. He created urgency, alleged mental instability, provided third-party corroboration, got the temporary order. Now he gets physical possession of Caleb before you can respond." I stared at the beige courthouse wall. Why would Laura sign something like that? Rachel didn't answer immediately. "We'll deal with her later. Right now, our priority is vacating the order." The clerk called Rachel's name. She collected the certified copies, and we moved to an empty table near the windows. Rachel opened her laptop and began drafting. "Emergency motion to vacate temporary allocation of parental responsibilities," she read aloud as she typed. "Grounds: lack of service, false representations, fabricated medical evidence, and imminent harm to minor child through abrupt custodial disruption." "Is that strong enough?" I asked. "It's accurate," she said. I pulled out my phone and called my office manager at the dental clinic. "Carol," I said, "I need a favor. Can you email me yesterday's patient schedule and time stamps? Including Marjorie Klein's appointment at 3:30. "Of course," she said. "Is everything okay?" "I'll explain later." Next, I logged into the employee portal and downloaded my timesheet for the week. It showed I had clocked in at 8:02 a.m. and clocked out at 5:11 p.m. the previous day. Rachel glanced at the documents. "Good. That contradicts any claim you were hospitalized yesterday." "What about the social worker letter?" "We'll subpoena the practice if necessary," she said. "If it's fake, that's perjury." The word hung in the air. At 11:15 a.m., Rachel submitted the emergency motion electronically and requested an immediate hearing. "We may not get it today," she said, "but we've created a record." My phone buzzed. It was a text from Daniel. "Picking Caleb up at 3. Don't make a scene." I stared at the screen for a long moment before responding. "I will be at the school." His reply came almost instantly. "You don't have legal authority anymore. Check the order." I did not answer. Rachel looked at me. "Save every message." "I am." At 12:40 p.m., the clerk's office called Rachel's cell. "The judge can see you at 1:30, she said after hanging up. My pulse spiked. "Before dismissal?" "Yes." We moved quickly to courtroom 3B. The courtroom was smaller than I remembered. A single row of benches. A raised bench for the judge. The county flag in the corner. Daniel was already there. He stood when we entered, wearing a navy blazer and the same expression he had used during our divorce. Controlled indignation. Beside him was Mr. Anders, the same attorney who had been at the school. Daniel did not look at me. Rachel and I took seats at the opposite table. At 1:32 p.m., Judge Evelyn Harper entered. "All rise," the bailiff said. We stood. The judge sat and looked down at the file. "We are here on an emergency motion to vacate temporary allocation of parental responsibilities," she said. "Ms. Halloran, you were not present for yesterday's petition." "No, Your Honor," Rachel said. She was not served and had no notice. Judge Harper looked at Daniel's attorney. "Mr. Anders?" "Your Honor, this was an urgent matter involving alleged mental instability and risk to the minor child." "Is Ms. Halloran currently hospitalized?" the judge asked. "No, Your Honor," Rachel said immediately. "She was at work yesterday during the alleged time frame. We have time-stamped employment records." Rachel handed the documents to the bailiff, who passed them to the judge. Judge Harper reviewed them silently. "Mr. Mercer," she said, looking at Daniel, "your affidavit states that Ms. Halloran was advised to seek inpatient treatment." "Yes, Your Honor." "By whom?" "A licensed clinical social worker." "Is that individual present today?" "No, Your Honor." "Was there any documentation beyond the letter attached?" "No." Rachel stood. "Your Honor, we have reason to believe that letter is either fabricated or misattributed. My client has never been evaluated by that provider." Judge Harper's expression did not change. "Mr. Anders, did you verify the authenticity of the letter?" "It was provided by my client," he said carefully. The judge looked at Daniel again. "Mr. Mercer, have you personally witnessed any behavior that posed an imminent threat to your child?" Daniel hesitated just slightly. "She's been erratic," he said. "Unpredictable." "Specifics," the judge said. "She cries. She isolates him. She doesn't let me see him." Rachel rose again. "Your Honor, Mr. Mercer has supervised visitation pursuant to a prior order. That supervision requirement was based on documented instability on his part." Daniel's jaw tightened. Judge Harper looked back at the file. "Ms. Halloran, have you ever threatened self-harm in the presence of your child?" "No, Your Honor." "Have you ever left him unsupervised for several hours?" "No." "Have you been hospitalized for psychiatric reasons?" "No." Judge Harper turned to Mr. Anders. "Where is the third-party affiant, Ms. Laura Simmons?" "Not present, Your Honor." The judge set down the papers. "This court takes allegations of parental mental instability very seriously," she said. "However, ex parte emergency orders require credible, verified evidence of imminent harm." She looked directly at Daniel. "At this time, I do not find sufficient evidence to maintain the temporary allocation without a full hearing." My breath caught. "I am vacating the temporary order effective immediately," she continued. "A full evidentiary hearing will be scheduled within 10 days. Until then, the prior custody arrangement remains in place." Rachel squeezed my arm under the table. Daniel's face went pale. Judge Harper was not finished. "Mr. Mercer," she said, "if any document submitted to this court is found to be fraudulent, there will be consequences." Daniel nodded stiffly. The gavel struck once. We were dismissed at 1:57 p.m. Dismissal at Ridgeview was at 3:05. Rachel turned to me as we stepped into the hallway. "Go to the school," she said. "Bring a certified copy of the vacated order." "Are you coming?" "I have to file this with the clerk immediately and ensure it's transmitted to the school. But you need to be there physically." I nodded. At 2:18 p.m., I walked back into Ridgeview Elementary School with a certified court order in my hand stating that I was, in fact, still my son's legal guardian. Mrs. Donnelly looked up as I approached the desk. "I have an updated court order," I said calmly. Principal Whitmore emerged from her office. She read the first page, then the second. "I see," she said. "Yes," I replied. At 2:46 p.m., Daniel walked into the front office. He saw me immediately. For the first time that day, he looked uncertain. Principal Whitmore stepped between us. "Mr. Mercer," she said evenly, The temporary order has been vacated. The prior custody arrangement stands. Daniel's eyes flicked to the paper in my hand. That's not possible, he said. It is, I replied. The bell rang down the hallway. At 3:05 p.m., Caleb came running toward the office with his backpack bouncing against his shoulders. He saw both of us. Mom, he said, confused. I crouched down and opened my arms. I'm here, I said. And this time, no one told me I wasn't allowed to take him home. Caleb didn't ask questions in the hallway. He just wrapped his arms around my neck and started talking about a science experiment involving vinegar and baking soda. I let him talk. I kept my face neutral. I did not look at Daniel again. Principal Whitmore watched us carefully, then turned to Daniel. Mr. Mercer, I suggest you contact your attorney. Daniel's jaw tightened. This isn't over, he said, low enough that only I could hear. I know, I replied. We left. In the car, Caleb buckled himself in and asked, why was Dad here? He had paperwork, I said. The judge fixed it. Caleb accepted that explanation. 9-year-olds trust systems in ways adults no longer can. When we got home, I did 3 things immediately. First, I scanned the vacated order and saved it to 3 different cloud folders. Second, I emailed a copy to the front office at Ridgeview Elementary School with a formal request that it be added to Caleb's permanent file. Third, I changed the emergency pickup authorization list to remove Daniel pending further court clarification. Under Illinois law, even non-custodial parents retain certain educational rights, but physical pickup is governed by custody orders. Rachel had been clear about that distinction. At 4:12 p.m., my phone rang. It was Laura Simmons. I let it go to voicemail. 30 seconds later, a text appeared. I didn't know it would go this far. Please call me. I did not respond. Instead, I forwarded the message to Rachel. At 5:03 p.m., Rachel called me. The judge was not pleased, she said. I spoke briefly with the clerk. There's going to be scrutiny on the affidavit and that social worker letter. Laura just texted, I said. What did she say? That she didn't know it would go this far. Rachel exhaled slowly. That's useful. I don't understand why she would sign something. People sign things for different reasons, Rachel said. Pressure. Misinformation. Money. We'll find out. That night, after Caleb went to bed, I sat at the kitchen table with the full court packet spread out in front of me. I read Daniel's affidavit again. He claimed I had become increasingly paranoid, that I had isolated Caleb from paternal relatives, that I had displayed erratic emotional outbursts. He cited an incident 2 weeks earlier. I knew exactly what he was referring to. 2 Saturdays ago, Daniel had shown up 20 minutes late to a supervised visitation session at the community center. When I refused to extend the session beyond the scheduled 2 hours, because the supervisor had another appointment, Daniel raised his voice. I told him calmly that the schedule was court-ordered. That was it. No outburst. No instability. A boundary. And now that boundary had been reframed as mental illness. I opened my laptop and searched the name of the clinical social worker listed on the letter. The practice existed. The provider existed. The letterhead matched the website. I dialed the office number the next morning at 9:03 a.m. A receptionist answered. Good morning, Naperville Behavioral Wellness. My name is Vanessa Halloran, I said evenly. I need to verify whether a letter was issued from your office regarding my mental health. There was a pause. Are you a current patient? She asked. No. Then I'm not sure. I have a copy of a letter submitted to the DuPage County Family Court yesterday, stating that I was evaluated by your provider for acute depressive symptoms. Another pause, longer this time. Can you hold, please? I waited. After 3 minutes, a different voice came on the line. This is Dr. Patel, she said. How can I help you? I repeated my statement. I have never seen you as a patient, Dr. Patel said immediately. We did not issue any letter regarding you. Would you be willing to provide a written statement confirming that? I asked. Yes, she said without hesitation. If someone is using our letterhead fraudulently, we need to know. I can email you a copy of what was filed, I said. Please do. Within 10 minutes, I had forwarded the scanned letter to the email address she provided. At 10:27 a.m. she replied, "This document is not from our office. The formatting is incorrect, and the signature is not mine. We will be reporting this." I forwarded that email to Rachel with the subject line, "Confirmed fraud." At 11:15 a.m., Rachel called. "That's significant," she said. "Forgery of a medical professional's letter to obtain a court order is serious." "How serious?" "Potentially criminal." I leaned back in my chair. "What about Laura?" I asked. "I'm drafting a subpoena for her testimony at the full hearing," Rachel said. "But before that, I want to know whether she actually signed the affidavit or whether Daniel forged that too." The affidavit bore Laura's typed name and an electronic signature. "I'm going to knock on her door," I said. Rachel paused. "Do not confront her aggressively. And document the interaction." "I'm not interested in yelling," I said. "I want facts." Laura lived 3 houses down. At 12:02 p.m., I walked to her front porch and rang the bell. She opened the door almost immediately. Her face was pale. "Vanessa," she said, "I was going to call you." "I got your text," I said. "I need to know whether you signed an affidavit stating that I'm mentally unstable and neglecting my child." Her eyes filled with tears instantly. "I didn't know they were going to use it like that," she said. "So you did sign something." She stepped aside and gestured for me to come in. "I need to record this," I said calmly, holding up my phone. She nodded. We sat at her kitchen table. "Daniel came over last week," she began. "He said he was worried about Caleb. He said you'd been crying a lot, that you were overwhelmed. He asked if I'd ever noticed anything concerning." "And what did you say?" I asked. "I said I'd seen you upset once," she admitted. "When your car wouldn't start." "That's it?" I asked. "Yes. Did you ever tell him I left Caleb unsupervised for hours?" "No," she said quickly. "Never." "Did you ever say Caleb was afraid of me?" "No." She started crying harder. "He brought a paper," she said. "He said it was just a statement that I'd observed you stressed and that he was concerned. He said it was to get you some help. I didn't read it carefully." "Did you sign it electronically?" "He emailed me something," she said. "I typed my name." "Did you see the final version that was filed?" She shook her head. I let the silence sit for a moment. "Laura," I said, "your statement was used to take custody of my son yesterday." Her shoulders collapsed. "I'm so sorry," she whispered. "Are you willing to provide a sworn statement clarifying what you actually said?" "Yes," she said immediately. "Whatever you need." I stood up. "I'll have my attorney contact you." As I walked back home, I felt something settle into place. Daniel's strategy had been layered. First, create a narrative of instability. Second, secure a fraudulent medical letter. Third, obtain a neighbor's signature under false pretenses. Fourth, file an emergency petition. Fifth, notify the school before I could respond. It had almost worked. That afternoon, Rachel filed a supplemental motion attaching Dr. Patel's email confirming the letter was fraudulent. She also attached my employment records and a sworn statement from me denying every allegation. The full hearing was set for the following Wednesday at 9 a.m. 5 days. Daniel exercised his supervised visitation that weekend. I insisted on strict adherence to the court order. The supervisor documented everything. Caleb returned home Sunday evening and said only, "Dad was quiet." On Monday morning, I requested a formal meeting with Principal Whitmore. We sat in her office at 8:30 a.m. "I need to understand your protocol," I said. "When you receive an emergency custody order, do you verify it directly with the court?" She folded her hands. "We verify the case number and judge's signature." "Do you notify the existing guardian before changing pickup authorization?" "We are not required to." "Even if the allegations are unverified?" She hesitated. "We are not investigators." "I understand that," I said. "But you are making decisions that affect a child's stability." She nodded slightly. "We acted in accordance with district policy." "I'd like a copy of that policy," I said. She agreed to provide it. I also requested a written log of who accessed Caleb's file after Daniel submitted the order. I want to ensure no additional information was shared beyond what was required, I said. She agreed to review that as well. I left the meeting with documentation requests in writing. On Tuesday afternoon, Rachel called again. The state's attorney's office has been notified about the forged letter, she said. Dr. Patel filed a complaint. What does that mean? It means Daniel may be facing more than a custody dispute. I sat down slowly. Is he going to jail? It's too early to say, she replied. But forging a medical document submitted to a court is not minor. The next morning, we returned to courtroom 3B. Daniel was there again. This time, Laura was seated behind him, visibly anxious. Dr. Patel was not present, but her sworn affidavit had been filed. Judge Harper took her seat. We are here for a full evidentiary hearing regarding the petition for temporary allocation, she said. Rachel stood. Your Honor, we move to dismiss the petition in its entirety and request sanctions based on fraudulent filings. Mr. Anders rose. Your Honor, my client relied on information provided to him in good faith. Judge Harper looked directly at Daniel. Mr. Mercer, she said. Did you submit a letter purporting to be from Dr. Anika Patel? Yes, he said. Did you verify its authenticity? He hesitated. I received it by email, he said. From whom? The judge asked. He glanced at Mr. Anders. From a contact, he said. That is not an answer, the judge replied. Rachel stood again. Your Honor, we have a sworn affidavit from Dr. Patel stating that the letter is fabricated and not from her office. The bailiff handed the document to the judge. The courtroom was silent as she read. When she finished, she looked at Laura. Miss Simmons, she said. Did you sign an affidavit in support of this petition? Laura stood, trembling slightly. I signed something, she said. But it didn't say what ended up in court. Did you allege that Ms. Halloran left her child unsupervised for hours? The judge asked. No, Laura said firmly. Did you allege that the child was afraid of his mother? No. Judge Harper turned back to Daniel. Mr. Mercer, do you understand the seriousness of submitting false information to this court? Daniel's composure finally cracked. I was trying to protect my son, he said. From what? The judge asked. He had no answer. Judge Harper leaned back in her chair. This petition is dismissed with prejudice, she said. The temporary order was vacated appropriately. Furthermore, the court will refer this matter to the state's attorney for review of potential perjury and fraud. Daniel's face went white. Additionally, she continued, given the attempt to manipulate judicial process, the court is modifying visitation. Supervised visitation shall continue, but frequency will be reduced pending further review. The gavel struck once. It was over. In the hallway, Daniel did not look at me. Mr. Anders avoided eye contact entirely. Laura approached me quietly. I'm so sorry, she said again. I know, I replied. But next time, read what you sign. Rachel walked beside me toward the elevator. He overreached, she said. That's what saved you. I thought about that. It wasn't emotion that reversed the order. It was documentation. Timestamps. Employment records. A forged letter exposed. A neighbor willing to correct the record. And a judge who required specifics instead of general accusations. At 3:05 p.m. that afternoon, I stood again in the hallway of Ridgeview Elementary School. When Caleb ran toward me, there were no attorneys, no court orders, no uncertainty. Just my son. And no one in that building could say I wasn't his legal guardian anymore. I thought the court's dismissal would end it. It didn't. 3 days after the hearing, I received a certified letter from the Illinois State Police requesting that I contact a detective regarding a report of suspected document fraud. The report number matched the complaint Dr. Patel's office had filed. I called immediately. Detective Alvarez asked me to come in the following morning to provide a statement and bring copies of all relevant court filings. At 9 a.m., I sat in a small interview room at the DuPage County Sheriff's Office with a digital recorder on the table between us. State your name for the record, Detective Alvarez said. Vanessa Marie Halloran. He asked me to describe the sequence of events. The school notification, the emergency petition, the forged social worker letter, the vacated order, and the hearing. I spoke slowly, chronologically, referencing dates and times. Did you ever authorize anyone to obtain or create medical documentation on your behalf? He asked. No. Did you ever consult Dr. Anika Patel? No. Did you ever sign a release allowing Mr. Mercer access to your medical information? No. He wrote everything down. Did Mr. Mercer contact you prior to filing the petition? He asked. No. Did he ever express concern about your mental health directly? No. The interview lasted 42 minutes. Before I left, Detective Alvarez said, "We'll be interviewing Mr. Mercer and reviewing the electronic trail associated with the letter submission." Electronic trail? I asked. The metadata, he said. Email headers. IP addresses. File creation history. I nodded once. Documentation again. 2 weeks passed. Caleb returned to routine. School. Homework. Soccer practice. I maintained strict compliance with the custody order. Every exchange with Daniel occurred in the presence of a supervisor. I kept written logs of dates and times. At work, I requested a letter from my employer verifying my consistent attendance and performance over the past year. I did not want any future allegation to stand without immediate contradiction. One afternoon, Principal Whitmore called me into her office again. "I want to update you," she said. "We've reviewed our protocol regarding emergency custody filings." I listened. "We are implementing an additional verification step," she continued. "If a temporary order is submitted without prior notice to an existing guardian, we will now contact the court clerk directly before altering pickup authorization." "That's appropriate," I said. She nodded. "We regret the distress this caused." "I understand you followed policy," I replied. "But policy can evolve." She handed me a printed copy of the updated procedure. I read it carefully. It required direct confirmation from the issuing court and immediate notification to all listed guardians before changes took effect. It was a small institutional correction, but it mattered. 3 weeks after the hearing, Rachel called again. "The state's attorney has filed charges," she said. "What charges?" "Forgery of a medical document, filing a false instrument, attempted perjury." I sat down at my kitchen table, the same place where I had first opened the court packet. "What does that mean for custody?" I asked. "It doesn't change the current arrangement immediately," she said, "but it significantly weakens his position if he attempts further modifications." "Will there be a criminal trial?" "Yes." I did not feel satisfaction. I felt something closer to confirmation. Daniel had not simply made a desperate parenting mistake. He had constructed a false narrative and attached fabricated evidence to it. That has consequences. A preliminary criminal hearing was scheduled for the following month. I attended, though I was not required to speak. The courtroom was different this time. Criminal division instead of family court. The judge reviewed the charges. The prosecutor outlined the allegation that Daniel had digitally altered a publicly available letterhead template to create a fraudulent clinical document. The metadata analysis showed that the letter had been created on Daniel's home computer at 11:18 p.m., 2 nights before the filing. The email transmitting it to his attorney originated from his personal account. Mr. Anders withdrew as counsel shortly thereafter. I watched from the back bench as Daniel stood at the defendant's table. He looked smaller. After the hearing, the prosecutor briefly introduced herself to me. "We'll likely offer a plea," she said, "but we will require an admission of wrongdoing." "Will the court be notified?" I asked. "Yes. Family court will receive notice of the criminal disposition." That mattered, because custody decisions consider patterns of deception and stability. At home that evening, Caleb asked me why I had been gone longer than usual. "Court stuff," I said. "Is Dad in trouble?" he asked. I chose my words carefully. "Dad made a bad decision about paperwork," I said. "Adults have rules too." He nodded. That was enough for now. 2 months later, Daniel entered a plea agreement. He admitted to submitting a falsified document to the court. He received probation, mandatory counseling, and a fine. The conviction was recorded. Family court held a follow-up review hearing shortly afterward. Judge Harper referenced the criminal disposition directly. "Mr. Mercer," she said, Your conduct demonstrates a willingness to manipulate judicial process to gain advantage. She modified the custody order again. Supervised visitation remained, but the frequency was reduced to once per month, contingent on compliance with counseling and probation terms. Additionally, the court ordered that any future petitions for modification must include certification from a licensed attorney that all supporting documents had been independently verified. Rachel leaned toward me afterward and whispered, "That's significant. It limits his ability to file impulsively." I nodded. Outside the courthouse, Daniel did not approach us. He left through a side exit. Life did not return to some cinematic version of normal. There were still exchanges. There were still calendars to coordinate. There were still moments when Caleb asked difficult questions. But something fundamental had shifted. The narrative Daniel tried to construct, that I was unstable, unsafe, unfit, had been formally rejected. Not emotionally. Legally. 6 months after the initial incident, I received a letter from the district office of Ridgeview Elementary School. It stated that following internal review, staff training had been updated regarding emergency custody orders and documentation verification. It was signed by the superintendent. I filed it in the same labeled box in my hall closet. One evening, while organizing paperwork, I looked again at the original emergency petition Daniel had filed. I kept a copy, not out of anger, out of record. It is 3 pages of typed allegations that read convincingly if you don't know me. That's what I learned. Paper can look official. Signatures can look authentic. Seals can look legitimate. Until someone asks for specifics. Until someone requests timestamps. Until someone calls the provider whose name appears at the bottom of the page. When I dropped Caleb off at school the following fall for 4th grade, Mrs. Donnelly smiled at me the way she always had before that morning in March. "Good morning, Vanessa," she said. "Good morning," I replied. There were no meetings in the principal's office. No gratuite veternis. No printed orders waiting behind a desk. Just a normal school day. But I still carry a certified copy of the standing custody order in my glove compartment. Not because I expect another ambush. Because I understand now how quickly a narrative can be filed, stamped, and transmitted. And how important it is to respond with documents instead of panic. On the morning the principal told me I was no longer my son's legal guardian, I did not argue loudly. I asked for copies. I requested transmission logs. I went to the courthouse. I gathered records. I verified signatures. And when the judge asked for specifics, I had them. That is why, at 3:05 p.m. that day and every day since, when Caleb walks out of Ridgeview Elementary School, he walks toward me. Not because someone granted me permission, but because the record reflects the truth. 2 weeks after Daniel entered his plea, I met with Rachel again to discuss whether we should pursue a civil action for attorney's fees and damages related to the emergency filing. Family court can award fees when one party acts in bad faith, she said, spreading out the billing statements across her desk. And a fraudulent filing qualifies. I looked at the total. Between the emergency motion, the expedited hearing, the full evidentiary hearing, and the subsequent review, my legal fees had exceeded $12,000. Will the court order him to pay it? I asked. Possibly, she said. Given the criminal plea, the argument is strong. Then file it, I said. I did not hesitate. The financial strain was real. I had used savings to cover the retainer for the emergency hearing. I had canceled a planned summer trip with Caleb. I had postponed replacing the transmission in my car. Bad faith litigation is not just emotional. It is expensive. Rachel filed a petition for attorney's fees, supported by the criminal conviction and the court's prior findings. The hearing was scheduled 6 weeks later. In the meantime, I made additional changes. First, I placed a fraud alert on my credit file. If Daniel was willing to fabricate a medical letter, I was not going to assume he would stop there. Second, I requested certified copies of Caleb's birth certificate and kept them in a fireproof safe. Third, I met with Caleb's pediatrician and asked that no medical information be released without my in-person verification and a secondary password. I documented that meeting as well. I was not reacting emotionally. I was building safeguards. At the fee hearing, Daniel appeared thinner. His probation officer had required him to attend weekly counseling sessions. He stood quietly while Rachel outlined the costs incurred as a direct result of his fraudulent petition. "Your Honor," she said, "but for Mr. Mercer's false representations and fabricated documentation, these proceedings would not have occurred." Daniel's new attorney did not contest the conviction. Instead, he argued financial hardship. Judge Harper reviewed the billing statements. "Mr. Mercer," she said, "the court finds that your actions necessitated emergency litigation. You will reimburse Ms. Halloran for reasonable attorney's fees in the amount of $10,400, payable over 12 months. Daniel nodded once. It was not the full amount, but it was formal acknowledgement. Outside the courtroom, his attorney approached Rachel briefly to confirm payment logistics. Daniel did not speak to me. That evening, I updated my spreadsheet. I track everything: dates of visitation, payment receipts, school communications, medical appointments, court filings. I added a new column labeled fee reimbursement. Caleb remained unaware of most of this, but he noticed small things. One Saturday afternoon he asked, "Why do you write everything down?" "So I don't forget," I said. "Forget what?" "Important details." He considered that. "Dad forgets stuff," he said matter-of-factly. I did not respond. Instead, I made a note to discuss that comment with his counselor. Because yes, Caleb had started seeing a child therapist after the emergency custody incident. Not because he exhibited trauma symptoms, but because abrupt legal disruptions can create confusion even when a child appears calm. The therapist provided me with a brief written summary after the first month. Child reports feeling confused by sudden changes in pickup plans, but expresses secure attachment to primary caregiver. It read, "Secure attachment." That mattered. 3 months after the criminal plea, Daniel missed a probation-mandated counseling session. His probation officer reported the violation. Family court was notified automatically because custody orders were tied to his compliance. A status review was scheduled. At that hearing, Judge Harper did not conceal her frustration. "Mr. Mercer," she said, "the court reduced your visitation frequency contingent upon counseling compliance. You are now in violation." Daniel claimed a scheduling conflict. The probation report contradicted him. The judge suspended visitation for 30 days pending proof of compliance. Caleb asked why he wasn't seeing his father that month. "Dad has some appointments he needs to keep," I said. "Once he does, the schedule resumes." Caleb nodded. He had stopped asking detailed questions. Routine had returned. But my vigilance had not. I requested a certified copy of the probation compliance order and added it to my file box. I also met with the school counselor to ensure she was aware of the court's findings, in case any future documentation was submitted. "I don't expect another emergency filing," I said. "But if one appears, I want you to contact me immediately before altering anything." She agreed. Documentation, communication, redundancy. 6 months after the original incident, Daniel filed a motion to modify visitation frequency back to twice monthly. Rachel called me as soon as it was docketed. "He's arguing rehabilitation," she said. "Completed counseling sessions. Probation compliance. Stable employment." "Is it accurate?" I asked. "Yes. The probation report confirms compliance for the past 8 weeks." I thought carefully. "Do we oppose it?" "We can request a gradual increase rather than immediate restoration," she said. "Then do that." At the hearing, Judge Harper reviewed the compliance records. "Mr. Mercer has met the minimum conditions," she said. "However, given the prior attempt to manipulate the court, restoration will be incremental." Visitation increased to twice monthly, but remained supervised. Daniel accepted the ruling without argument. Afterward, in the hallway, he spoke to me for the first time in months. "I made a mistake," he said. "Yes," I replied. "I wasn't trying to hurt Caleb." "But you did," I said. He looked down. "I thought if I got custody temporarily, things would calm down," he said. "By accusing me of being mentally unstable?" I asked evenly. He did not answer. "I will not tolerate another fabricated document," I said. "If you have concerns, Raise them through verified channels. He nodded once. It was not reconciliation. It was acknowledgement of boundaries. That night, I reviewed the original emergency order again. The language was stark. Immediate risk. Imminent harm. Temporary allocation. All triggered by a forged letter and an affidavit signed without scrutiny. I considered how easily the system had responded to those words, and how essential it had been to respond just as quickly with counter-evidence. In the months that followed, I was asked twice, once by another parent at school and once by a colleague at work, how I handled that custody scare. I answered the same way both times. I asked for copies, I said, and I went to the courthouse. There is a tendency to dramatize events like this, to describe them as battles or wars. It did not feel like that. It felt procedural, a sequence of filings, a sequence of verifications, a sequence of corrections. Nearly a year after the morning I was told I was no longer my son's legal guardian, I received a final notice from the state's attorney's office. Daniel's probation had concluded successfully. No further violations. The case was closed. I placed that letter in the file box as well, not because I needed to remember the offense, because I needed a complete record. On Caleb's 10th birthday, Daniel attended the supervised party at a local recreation center. He remained quiet, appropriate, distant. When the party ended, Caleb hugged him briefly. Then he ran back to me to open gifts. I watched the exchange without commentary. Later that night, Caleb asked, "Are things okay now?" "They're stable," I said. "What's the difference?" "Stable means the rules are clear," I replied, "and everyone is following them." He seemed satisfied with that. I turned off the lights in his room and closed the door. Then I walked to the hall closet, opened the labeled file box, and checked the documents one more time. Divorce decree, custody order, vacated emergency order, criminal disposition, probation completion, attorney fee reimbursement schedule. Each paper represented a step in correcting a false narrative. Each paper existed because I insisted on records instead of reacting to accusations. The morning the principal told me I wasn't Caleb's legal guardian anymore, I did not know how the week would end. I did not know there would be a criminal plea. I did not know there would be a policy revision at the school. I did not know there would be a probation officer, a forensic metadata analysis, or a reimbursement order. I only knew one thing. The document in front of me did not reflect reality. And reality, when documented correctly, has weight. That is what carried me through the hearings. That is what restored the custody order. And that is what ensures that if another stamped paper ever appears claiming I am not my son's guardian, I will respond the same way. With copies, with timestamps, with verification, and with a court record that already reflects the truth. About 14 months after the emergency petition, I received an unexpected phone call from the district's legal compliance office associated with Ridgeview Elementary School. The caller introduced herself as Denise Callahan, Director of Student Services. "We're conducting a procedural audit," she said. "Your case has been selected as part of our review of emergency custody response protocols." I agreed to meet the following week. When I arrived at the district office, Denise had a binder open on the conference table. Tabs labeled Initial Filing, Verification, Notification Timeline, and Policy Revision divided the contents. "We want to understand exactly what happened from your perspective," she said. "Not to reopen anything. To prevent repetition." I described the morning in the principal's office, the presence of Daniel's attorney, the immediate change in pickup authorization, the lack of direct court verification before implementation. Denise took notes. "Our revised protocol now requires direct clerk confirmation before any alteration of custodial status," she said. "Additionally, both listed guardians must be notified simultaneously." "That would have changed the timeline," I said. "Yes," she replied, "and it likely would have prevented the dismissal confusion." I nodded once. The district also implemented a requirement that any emergency custody order received electronically must include a transmission log and certified copy within 24 hours. If not, the prior custodial arrangement remains in effect until verified. It was a procedural safeguard built from my experience. I left the meeting with a written summary of the revised policy, Again, I filed it. Not because I expected to need it, because documentation creates continuity. 3 months later, another development occurred. Daniel filed a petition in family court requesting unsupervised visitation. Rachel called me immediately. He's completed counseling, probation, and paid the majority of the fee reimbursement, she said. He's arguing rehabilitation and stability. Does he have grounds? I asked. Legally, yes, she replied. Courts favor increased parental access when compliance is demonstrated. We prepared for another hearing. This time there were no emergency filings, no fabricated documents, no dramatic allegations. The proceeding was procedural. Daniel's probation officer testified that he had complied with all conditions. His counselor submitted a summary stating that he had completed anger management sessions and demonstrated improved impulse control. Rachel presented documentation of the prior fraudulent filing and the court's findings regarding credibility. Judge Harper listened carefully. Mr. Mercer, she said, you have taken steps toward compliance. However, this court cannot ignore the seriousness of your prior conduct. She paused. Visitation will transition from supervised to monitored exchange without a third-party supervisor. Exchanges shall occur at the designated visitation center with documented check-in and check-out times. Any deviation from court orders will result in immediate review. It was a cautious progression, not a restoration of trust, a structured trial period. I accepted the ruling. After the hearing, Rachel said quietly, "This is incremental. The court is testing consistency." I understood. That afternoon, I explained the change to Caleb. "You'll see Dad without the supervisor in the room," I said. "But exchanges will still be at the center." He nodded. "Is that good?" he asked. "It's a change," I replied. "We'll see how it goes." The first unsupervised visit under the new structure occurred 2 weeks later. Caleb returned home calm. "What did you do?" I asked. "Went to the park," he said. "Dad didn't talk about court stuff. That mattered." For months after the emergency filing, Caleb had occasionally asked whether I was sick or whether someone was taking him away. Those questions had stopped. Stability is quiet. No headlines. No courtroom drama. Just routine. 16 months after the initial incident, I received the final reimbursement payment from Daniel. The check cleared. I updated my spreadsheet and marked the column complete. I also reviewed the entire file from beginning to end. The original emergency petition, the vacated order, Dr. Patel's affidavit, the criminal plea agreement, the probation completion notice, the visitation modification orders, the fee reimbursement judgment. It formed a complete arc. From accusation to correction, from forged letter to verified record, from temporary removal to restored status. One evening, while organizing documents, I found the envelope from the day I first went to the courthouse. It still had the clerk's timestamp in blue ink across the top corner. 3:42 p.m. The exact time the emergency order had been signed the day before. Time matters in court. Sequence matters. Because when Daniel filed his petition at 2:57 p.m., he created a narrow window where I was unaware and unable to respond. When Rachel secured a hearing at 1:30 p.m. the next day, that window closed. Documentation compresses uncertainty. It shortens the lifespan of false narratives. 2 years after the morning I was told I was no longer Caleb's legal guardian, Daniel filed no further emergency motions. He complied with the monitored exchanges. He attended parent-teacher conferences quietly. He did not attempt to access school records outside authorized channels. The system had recalibrated. One afternoon, I was invited to speak at a local legal education seminar for school administrators about emergency custody documentation procedures. Denise from the district had recommended me as a parent who had experienced the impact of rapid order implementation. I agreed with one condition. I would not discuss Caleb's personal details. At the seminar, I stood in front of approximately 40 administrators and school counselors. "I'm not here to criticize," I said. "I'm here to explain what it feels like to be told you are no longer your child's legal guardian, based on paperwork you haven't seen." I described the importance of direct court verification, the importance of simultaneous guardian notification, The importance of distinguishing between allegation and adjudication. Afterward, several administrators approached me. "We're revising our protocol," one said. That was enough. The incident had begun with a document that looked official. It ended with multiple institutions refining their verification processes. Caleb is 11 now. He knows more about courtrooms than most children his age, but not because I burden him with details. Because he once saw adults in suits talking in a school office and later asked questions. When he asks now about that week, I answer simply. Sometimes adults file papers that aren't accurate, I say. When that happens, you correct the record. He accepts that. On the anniversary of the day the emergency order was vacated, I did something deliberate. I drove to the DuPage County Courthouse alone. I walked up to the third-floor clerk's office. I requested a certified copy of the standing custody order, not because it had changed, but because I wanted a fresh seal and current date. The clerk printed it, stamped it, handed it to me. I held it for a moment. Paper. Ink.
Seal. Signature.
Legitimacy verified. I placed it in a new folder labeled Current. Because if there is one thing I learned from the morning I was told I was not my son's legal guardian, it is this. Authority on paper can shift quickly, but the record, when challenged with facts, can shift back just as decisively. And every afternoon at 3:05 p.m., when Caleb walks out of Ridgeview Elementary School, or now the middle school across town, he walks toward the person whose name remains exactly where it belongs on every verified document. Mine. The third year after the emergency filing passed without new litigation, but I did not allow complacency to replace preparation. In January, I conducted what I privately call a document audit. I pulled every custody-related paper from the file box and cross-checked dates, signatures, and compliance terms. I verified that Daniel's visitation schedule reflected the most recent court modification. I confirmed that the school had the updated order on file. I requested a fresh attendance report from the visitation center showing no missed exchanges. It may sound excessive. It is not. When someone has once attempted to reclassify you as an unfit parent through paperwork, you do not assume silence equals safety. That same winter, Daniel sent an email requesting a meeting to discuss co-parenting communication improvements. I did not ignore it. Instead, I replied in writing. All co-parenting matters will continue to be addressed through the Parenting Communication app, as previously agreed. If you wish to modify the existing communication structure, please file a motion with the court. He did not respond further. Boundaries documented are boundaries enforceable. In March, Caleb brought home a school assignment titled My Family Story. It required students to describe significant events that shaped their family. He sat at the kitchen table, pencil in hand. "Can I write about the time you went to court?" he asked. "You can write about anything important to you," I said. He thought for a moment. "Was that important?" he asked. "Yes," I said. "It was." He wrote for 15 minutes, erasing occasionally. When he finished, he handed me the paper. It did not mention fraud or custody orders. It said, "One time my dad tried to change who picked me up from school. My mom went to court and fixed it. Now things are more organized." Organized. That was how a 10-year-old interpreted emergency litigation and criminal charges. Not betrayal. Not crisis. Organization restored. I folded the paper and placed it in the same file box, because it too was part of the record. In May, Daniel filed his first petition in over a year, this time requesting joint decision-making authority for educational matters. Rachel called me as soon as it was served. "He's not alleging instability," she said. "He's arguing sustained compliance and desire for greater involvement. Is that unreasonable?" I asked. "Not inherently," she replied. "But given the prior attempt to manipulate school records, we need safeguards." We prepared a response proposing limited joint decision-making contingent upon written agreement that no educational record changes could occur without dual written consent. At the hearing, Judge Harper reviewed the history. "Mr. Mercer," she said, "your prior attempt to alter custodial status through fraudulent means directly involved educational access. Why should this court grant joint educational authority?" Daniel answered carefully. "I understand the harm I caused," he said. "I'm asking for structured involvement, not unilateral control." The judge considered that joint educational decision-making will be granted on a trial basis of 12 months, she ruled. Any attempt to modify records without documented mutual consent will result in immediate revocation. The order was specific. It required that any submission to the school include both our signatures or documented electronic approval through the parenting app. It also required that the school maintain a copy of the court's warning language in Caleb's file. After the hearing, Rachel said quietly, "The judge is building accountability into every layer." I agreed. The system had learned as well. The first time Daniel and I exercised joint educational authority was over a field trip form. He submitted a draft response in the parenting app, asking whether Caleb could attend an overnight science camp. I reviewed it. "I approve," I wrote back. "Submit with both signatures attached." He complied. No shortcuts. No unilateral emails to the principal. No gray-suited attorney appearing unannounced. Just a signed PDF uploaded through the designated channel. Procedure. That summer, Caleb transitioned to middle school. On orientation day, I met with the new front office staff and provided a certified copy of the standing custody order and the joint decision-making modification. "I'm not expecting issues," I said evenly, "but I want clarity." The administrative assistant reviewed the documents carefully. "We'll scan these into the system," she said, "and note the requirement for dual consent on any changes." I left with written confirmation of receipt. The first day of 6th grade passed without incident. No calls. No emergency meetings.
No allegations.
Routine can feel uneventful after years of litigation. It is not uneventful. It is earned. In October, Daniel completed the final year of counseling recommended by the court. He requested removal of the monitored exchange requirement. Rachel advised caution. "We can agree to removal of the visitation center exchange provided that exchanges occur in a public location and are documented through the app," she said. We negotiated terms. The court approved the modification. Exchanges moved to the parking lot of the local library, with required timestamp check-in messages. I continued to log every exchange, not because I anticipated misconduct, because record-keeping is neutral protection. One evening, after a smooth exchange, Daniel lingered briefly. "I know you don't trust me," he said. "I trust documentation," I replied. He nodded once. "That's fair," he said. It was the first honest exchange we had had in years. Trust in our case would never be casual. It would be structured, measured, documented. Nearly 3 years after the emergency petition, I conducted another audit of Caleb's school records. I submitted a formal written request for a copy of his cumulative file. Under federal and state law, parents have the right to review educational records. I examined every page. Enrollment forms, emergency contacts, report cards, disciplinary logs. There was no notation indicating I had ever been removed as guardian. The temporary order had been documented as vacated the same day it was received. The system reflected correction. I returned the file to the office and requested written confirmation that no unauthorized access had occurred since the policy revision. The data report showed no irregular access. I kept a copy. That winter, Caleb asked a more direct question than he had before. "Did Dad lie about you?" he said quietly. I paused before answering. "He submitted information to the court that wasn't accurate," I said. "Why?" "He thought it would help him get more control," I replied. "Did it?" "For about 20 hours, I said. "He absorbed that. And then the judge reviewed the facts." He nodded slowly. "Facts matter," he said. "Yes," I replied. "They do." He went back to his homework. That sentence, "Facts matter," summarized 3 years of hearings more accurately than any legal brief. On the 4th anniversary of the morning I was told I was not my son's legal guardian, I did not go to the courthouse. I did not open the file box. I did not review timestamps. Instead, I went to Caleb's basketball game. I sat in the bleachers. I watched him run drills, call plays, argue mildly with a referee about a foul. Normal childhood. After the game, Daniel approached to congratulate him. We stood within 6 feet of each other. No eternis. No motion spending. Just co-parents in a gymnasium. Good game, Daniel said to Caleb. Thanks, Caleb replied. I nodded at Daniel. He nodded back. It was not reconciliation. It was equilibrium. The legal record remains intact. The criminal conviction remains recorded. The custody order remains structured. The school's policy remains revised. The file box in my closet remains organized. But daily life no longer revolves around emergency hearings. It revolves around homework, sports schedules, dentist appointments, and school concerts. The morning I was told I was not my son's legal guardian felt destabilizing because authority appeared to shift without warning. What restored stability was not confrontation. It was documentation. It was verification. It was insisting that allegations meet evidentiary standards. Years later, that remains true. If another stamped paper were ever to appear claiming I am unfit, unstable, or removed as guardian, I would respond the same way I did the first time. I would request copies. I would confirm service. I would verify signatures. I would gather timestamps. And I would let the record speak. Because in the end, the system does not respond to volume. It responds to evidence. And the evidence, preserved carefully and consistently, remains exactly where it belongs. And subscribe so you don't miss a part 2.